The name of the case was Awet Tekle versus David Hourigan. This was a case that arose out of a minor impact car accident that occurred at 9th and Mission in San Francisco.
We had a number of issues we had to address in the case. The first issue was that there were security cameras that recorded the incident.
It looked like a very minor impact, and the cars just glanced off each other or kissed in the intersection of 9th and Mission, when in fact the force of the impact was enough to cause great bodily injury to my client.
The case itself is not that unique. This is what the insurance industry calls a missed case, minor impact soft tissue. They bring in an accident reconstructionist who comes in and says that the forces involved in the collision weren't that great. We therefore put a lot of time and a lot of effort into dispelling all these defense myths that occur in these missed cases. What we found was that one of the structural steel beams in the front of the car had been bent 11 millimeters towards the center of the car. So that was a very important part. 11 millimeters does not seem like much, but if you can bend structural steel, you can certainly damage a disc. Before being injured, he was very physically fit. We were able to contrast that with all the surveillance and sub rosa video that the defense took of Awet after the collision. What you saw was a man in his late 20s walking slowly with a cane.
We were able to effect change for our client. He came to us with an issue and a problem that he needed help with, and I'm proud of the fact that all of that made a difference. And when the jury came back with their ruling, it came back on our side.
I'm grateful for Awet Tekle's intelligence and his fortitude.
I am grateful for Linda Ross, who gave me the opportunity to be involved in this case from intake to judgment.
I also want to thank Matthew Kimmons and Simon Gibbs.
The end result of this case was that our client got justice, and they awarded our client over $6.6 million. And with the addition of costs and interests due to the ignored 998, our client was awarded over $8.2 million.
This is Reed Robertson versus the city of Orinda. It was a bicycle accident late at night on a Sunday when Reed was riding home on a really old, substandard, narrow city street that had holes and cracks in it. And one of the cracks literally swallowed his tire, flipped him over, and he had a spinal cord injury.
This case is unique in that there was a lack of documentary evidence that we had at our disposal. The police showed up, but they didn't document the scene. They didn't write a report.
We were able to, through the use of an expert right after the accident, examine cracks in the roadway, found one crack that had metallic marks that matched the damage to the bike, and established that that's where the accident occurred.
Tom got the man in charge to concede that for years prior to this incident, the city had the means and resources to fix the condition of road that caused this incident, and it could have been done in an afternoon for less than $1,000.
The pivotal moment in the case in the terms of proving the liability was our ability to show through science and facts what actually happened. It refuted the defense theory that he was just going too fast. The other was through the use of our expert rehabilitation in the field of rehabilitation to show that while Reed has made this incredible recovery, regained the use of his legs, that his future still was grim.
I'm proud of the work in this case because it was a hard-fought, long battle. We had multiple mediations and settlement conferences where the defense offered $0. In the end, we were able to secure an award that will allow Reed to cover his significant future medical expenses.
The end result of the case was the jury held accountable the city of Orinda, and the net verdict to the client was $4.3 million.
I'm extremely grateful to our client, Reed Robertson, for trusting us throughout this process And I'm grateful to everyone at the Brandi firm who worked tirelessly.
Everybody just really pulled together within our firm, and it was really gratifying, the team effort we have.
The case was Alva and Albert Pilliod versus Monsanto Company. Is it a case that alleges that their exposure to the pesticide Roundup or glyphosate caused them both to separately develop rare types of lymphoma? What makes this case unique is that Monsanto has a history of beating and winning against these kinds of lawsuits. One of the most difficult aspects of the case is that the EPA and every regulatory body has actually concluded that Roundup does not cause cancer. Thankfully, we were able to convince the jury that it was not right. And actually, months later, we ultimately had that specific finding by the EPA taken down by the Ninth Circuit Court of Appeals. When you're trying a case against Monsanto, it's tough. They have the best lawyers. They have an army of associates and paralegals, and it's just you and your team, me and the Miller firm, just taking them on. And although Monsanto levied every single legal defense, attacks, you name it, each of them failed. And the Pilliods were able to secure a very, very, very good judgment. And we were able to get resolutions for hundreds of thousands of people in excess of over $16 billion. And I have to say that, the Miller firm, Mike Miller, who unfortunately has passed away recently, and his whole team, we worked in lockstep to accomplish this incredible verdict. Monsanto has now agreed to take Roundup off the residential market, so people like the Pilliods will never get exposed to Roundup again. And I think that was a statement to Monsanto and really to every chemical manufacturer on the planet that if you poison people, if you give them cancer, we are going to get you in court.
Our case is called De La Torre versus CashCall, Inc. The case is a consumer class action against CashCall, which is a lender.
We had two primary claims. One was the unconscionability claim, which we brought under the unfair competition law, and the second was a violation of the Electronic Funds Transfer Act.
I believe it's the only loan unconscionability case ever in this country to go to trial and go all the way to a verdict. And we were holding CashCall accountable for predatory lending practice.
So we had to use the California unconscionability law and prove that these loans were unconscionable at the time they were made. And in order to do that, we had to conduct extensive discovery into the commercial context of the loans, and we retained two experts on loan unconscionability.
So the pivotal moment was the time that the Ninth Circuit decided to transfer that appeal to the California Supreme Court, asking the California Supreme Court to decide whether the loans in this case was unconscionable, because that was solely a question of state law. As a result of the Supreme Court's decision that yes, indeed, these loans could be held to be unconscionable when the court considered the proper factors.
And that Supreme Court decision was part of the reason that the California legislature capped interest on loans such as this to, I believe it was 36% plus the federal funds rate.
The end result of the case after the 13-day trial was that the judges issued a proposed decision awarding the class $235 million in interest payments.
I think I'm most grateful for our co-counsel in the case, and that's Jim Sturdevant and Arthur Levy, who started this case back in 2008. This is an outstanding example of David succeeding over Goliath.